afternoon, everyone, and thanks so much for coming, and thanks to those in our online audience for tuning in. Sorry we couldn't feed you out there on the internet, but I hope you have lunch and watch the festivities. I'm Doug Kendall. I am the president of Constitutional Accountability Center. We are a think tank, law firm, and action center dedicated to the Constitution's text and history and the progressive promise of those sources. We're thrilled to be hosting this event today and honored to be joined by Senator Elizabeth Warren and Professor Lawrence Lessig. The title of today's event is called The Founders versus the Roberts Court: Corruption, Campaign Finance, and McCutcheon versus FEC. As the title suggests, we are here in part to discuss a Supreme Court case, McCutcheon versus FEC, which and it is an important follow-up to the Supreme Court's ruling in Citizens United versus FEC. McCutcheon will be argued before the Supreme Court on October 8th, the second day of the court's new term. To frame the conversation today, let me give you a little background, starting with Citizens United. In a sharply divided 5-4 ruling 3 years ago, the Supreme Court held that corporations can spend unlimited amounts on so-called independent expenditures to elect candidates of their choice. These expenditures are called independent because the money is not given to a party or a candidate, and in theory, at least, there is supposed to be no coordination between the expenditure and the campaign being supported. The ruling by the court's conservative wing in Citizens United is based on the equivalency of three things that are not really equal. The court held that money equals speech, corporations equal people, and corruption equals nothing more than bribery. Because money equals speech, the court held, and because corporations have the same speech rights as individuals, corporate expenditures on elections are subject to what the Supreme Court calls strict scrutiny, effectively the death knell for limits on campaign expenditures. Laws limiting such speech must be narrowly tailored to address a compelling government interest. And the court held for the first time in Citizens United that when it comes to independent expenditures, the government's compelling interest was limited to combating quid pro quo bribery and nothing else. With Citizens United, the court's conservative majority returned us to the Wild West in terms of regulating independent expenditures. McCutcheon is different from Citizens United in this important respects. It involves campaign contributions to candidates and parties. Specifically, McCutcheon involves aggregate limits of such campaign contributions. So limits the total amount any individual can give to a candidate or a party. Supreme Court has long distinguished contributions from expenditures because there's a greater risk of corruption when you're giving money directly to a candidate, and there's very little control over your money once you give the money to a candidate. It is much harder to equate money and speech in this context, and so the court has applied what it calls intermediate, not strict, scrutiny to contribution limits. And as a result, the court has generally upheld limits on contributions, at least so far. A key question in the McCutcheon case is whether the court will impose the new rules, the new limits it developed in Citizens United to laws that limit contributions. Specifically, will the court continue to assert in this context that the Congress's role is limited to combating bribery? That's a critical question that we'll be addressing today. CAC worked with Professor Lessig in preparing a brief that is submitted before the Supreme Court in the McCutcheon case. Our brief recounts the extraordinary results of Professor Lessig's scholarship into the founders' understanding of corruption and the federal government's power to combat corruption in our political processes. The founders understood what remains common sense to just about every American today. Money corrupts our political system in many ways. Smart donors are not demanding votes when they give their money. They acquire access and they cultivate dependency both by our candidates and our political parties. Professor Lessig's comprehensive account of the Constitution's original meaning should be particularly persuasive to the Supreme Court's conservatives who purport to be originalists and purport to be bound by the Constitution's text and history. We will see. As Citizens United indicates, the court's conservatives have departed rather sharply from the Constitution's text and history in recent rulings, most recently in the Supreme Court's ruling in Shelby County versus Holder, striking down a critical part of the Voting Rights Act. So the McCutcheon case represents a key test for conservatives on the court and for Chief Justice Roberts in particular. Will they follow the founders, or will they continue to pervert the Constitution and undermine our democracy? As important, Professor Lessig's work reflects a fundamental change in the way progressives are fighting back against the court's originalists. For decades, progressives have been arguing that conservatives have it all wrong, that the Constitution is a living document that evolves with the times, and therefore, who really cares about what the founders thought? Professor Lessig's research represents a revolutionary change. Top academics and Supreme Court advocates from the left and center now agree that the Constitution's text and history is critically important. And they're hard at work at documenting the many ways in which those sources point to progressive, not conservative outcomes on a wide range of issues, ranging from healthcare to immigration to voting rights and to campaign finance in the McCutcheon case. With the Tea Party right now trying to shut down the federal government based on a crackpot notion that the founders were disciples of Ayn Rand, it's hard to overstate the importance of this change. Progressives can no longer see the Constitution to conservatives. And as Professor Lessig's research and Senator Warren's presence here today attest, this is no longer happening. Senator Warren has done this nation a great service by very effectively highlighting the fact that when the court's conservatives depart from the Constitution's text and history, as in Citizens United, it very often does so to favor the interests of corporate America. The statistics here encompassed in studies by both Constitutional Accountability Center, our organization, and leading lights like Judge Richard Posner are extraordinary. Senator Warren has correctly warned of the corporate capture of the Supreme Court, and she has spoken poignantly about the impact of the court's pro-corporate rulings on the lives of hardworking Americans. And with that, I will turn the mic over to one of the nation's fastest rising political stars, a first-rate scholar, a passionate activist, and a senator who is quickly proving herself more than able to fill the enormous void in the Senate left by the death of Edward Kennedy, who held her seat for almost 50 years. Senator Elizabeth Warren.
Thank you. Hey, you. How are you? All right, we've got to get the hug out of the way first before we can get started here. So I want to thank you very much. I want to thank the Constitutional Accountability Center for pulling this event together, for inviting me here to speak. And I also want to thank Professor Lessig for this work. I've known Larry for a number of years. He is a first-rate legal scholar who is deeply committed to ensuring that our democracy works for all Americans, not just those with money and power. This is a great event because it gives me an opportunity to talk about the impact of concentrated power on our political process, how the founders viewed these concerns and how the Supreme Court can keep faith with those views. The founders greatly feared concentration of power, understanding how concentrated power undermines a democratic government. But here in Washington, power is not balanced. Instead, power is becoming more and more concentrated on one side. There are well-financed corporate interests lining up to protect their own privileges and to resist any change that would limit corporate excess. I saw one example of this up close and personal during the fights following the 2008 financial crisis and the attempt to get regulatory reform in place. But believe me, now that I've been around Washington, I have seen many, many more examples of this. Big corporate interests are savvy. They fight every day on Capitol Hill, and they fight every day in the agencies. They devote enormous resources to the task of bending legislation to benefit themselves. They also devote enormous resources to influencing the courts. Now, I've been speaking out about the intense fight that's going on right now over what our federal courts will look like. It's a fight over whether those courts will remain a neutral forum, faithfully interpreting the law and dispensing fair and impartial justice, or whether we'll see a corporate capture of the federal courts, with the courts turned into just one more rigged game. Right now, we're losing that fight. The most prominent example of this is in the United States Supreme Court. Three well-respected scholars, including Judge Richard Posner of the Seventh Circuit, a widely respected and very conservative Reagan appointee, recently examined almost 20,000 Supreme Court cases over the last 65 years. They used multivariate regression analyses so that they could determine how often each justice voted in favor of corporate interests during their time on the bench. Now, Judge Posner and his colleagues concluded that the 5 conservative justices currently sitting on the United States Supreme Court are among the 10 most conservative in over half a century. And Justices Alito and Roberts, number 1 and number 2. And take a look at the Chamber of Commerce. Let's take a look at their win rate. The Constitutional Accountability Center has done some amazing work here. It's shown how the Chamber has moved from a 43% win rate during the last 5 terms of the Burger Court. Think about that, 43% win rate. You ready? To a 56% win rate during the very conservative Rehnquist Court, to a 70% win rate during the Roberts Court. Now follow this pro-corporate tilt to its logical conclusion, and pretty soon the United States Supreme Court will become a wholly owned subsidiary of big business. The consequences of this pro-corporate shift are staggering. For example, the Lilly Ledbetter case. Supreme Court chose to protect employers over employees, ignoring the basic principle of equal pay for equal work. Supreme Court rewrote our established understanding of the standards for filing lawsuits in Iqbal and the Twombly cases, making it easier for rich corporations to beat poorer underdogs. The court looks for every opportunity to undermine class actions, which leave big corporations free just to roll over ordinary folks. Perhaps the most well-known of the court's recent pro-corporate decisions was Citizens United, which unleashed an avalanche of secret corporate money into our political system. In Citizens United, the Supreme Court famously suggested that Congress is permitted to root out corruption only in money-for-vote quid pro quo cases. In other words, the Supreme Court says that even if Congress wanted to act, it could deal with only a small piece of the overall corruption that stacks the deck in favor of big business and other special interests here in Washington. You know, it should be clear to anyone who is paying attention, that money for vote exchanges are not the only threat to our political system. Most deep pocket corporations don't need to be so crude. The power of well-funded special interests to blanket our politics with aggregate contributions tilts our democracy away from the people and toward the powerful. Congress needs power to address all of the ways in which corruption threatens the health of our political system. And that's where Professor Lessig's research comes in. Professor Lessig's research shows that this concern about widespread systematic corruption isn't just a product of our times, but it was a concern shared by the founders. When they drafted the Constitution, they weren't just protecting the system from money for votes corruption. Instead, they were even more concerned with preventing institutional corruption that makes our system more responsive to the special interests and less responsive to the people themselves. In the upcoming Supreme Court term, I know you all have been talking about this, the court will consider McCutcheon versus FEC, a case that could eliminate aggregate contribution limits by individual candidates to political committees. If the court continues in the direction of Citizens United, we may move another step closer to neutering Congress's ability to limit the influence of money in politics, and another step closer to unlimited corporate contributions given directly to candidates and political committees. We face a clear danger. Professor Lessig's research creates a glimmer of hope that the Roberts Court will keep faith with the framers. He shows a path that will give Congress the tools it needs to protect the health of our democracy and to ensure that the American people stand a fighting chance when decisions get made. So I hope, for the sake of this country, that the Supreme Court is listening. Thank you. And thank you, Larry. Thank you, Larry. Thank you for your work. I'm sorry we're in the
Thank you, Senator Warren. Senator Warren is busy trying to stop a government shutdown, so she can only join us for a few minutes here today. I'm just now going to very quickly introduce Professor Lawrence Lessig, who's going to take us through the remaining part of the program. Professor Lessig is probably the nation's foremost professor on issues of law and technology, and is becoming perhaps a foremost authority on issues such as money and politics. His book, Republic Lost, how the campaign finance system is broken and what we can do to fix it, something along those lines, is a wonderful book that both illustrates what is the strength of Professor Lessig's scholarship, which is that he not only diagnoses the problem, he provides a path to fix it. And I think his scholarship is uniquely both accessible and also powerful in terms of affecting the court and affecting the way activists around the country address problems like our broken political system and the flaws in our democracy. And with that, I will introduce and let Larry take it from here.
Great, thank you. So thank you, and thank you to the Center for the Constitutional Accountability Center, and to Professor Senator Warren for that very generous framing of this conversation. I want to lay out the argument in a way that I hope will engage people on the left and the right to recognize why this method of interpretation that people refer to as originalism isn't just for the right anymore. So as everyone recognizes, the word corruption has a certain magical power in the context of the First Amendment. The First Amendment, which otherwise says there shall be no law abridging the freedom of speech, is conditioned because If the speech is corruption, then essentially the court has said you can abridge away. So that means this question of what corruption means begins to bear significant weight. Now, the Supreme Court has addressed this question in a wide range of cases, beginning in the Buckley case in 1976. And the general frame they've adopted has said corruption involves a certain influence. And at times that influence is directed against members of government, and at times that influence is directed against the public. Now, when it's directed against the government, the standard form that has been adjudicated has been quid pro quo corruption. And that doesn't apply directly against Congress. It applies against particular members of Congress who have an influence within this economy of influence that produces this kind of corruption. And it is corruption because it steers those members away from a focus on their constituents. It is corrupting at the level of the individual member of Congress because it is undermining their representative capacity as members of Congress. Since Buckley, the court has said Congress has the power to regulate speech that is corruption. This kind of regulation is constitutionally fine, so long as its focus has been quid pro quo. Now, for a brief time, the court also considered the other direction for such corrupting influence. Michigan was motivated by its fear of the power of corporations to find a way to limit corporate power in the political speech market by passing a statute that disabled corporations from participating. And in 1990, the Supreme Court in Austin versus Michigan upheld that regulation. And what the court said was, quote, the corrosive and distorting effects of immense aggregations of wealth accumulated with the help of the corporate form with little or no correlation to public support for the corporation's political ideals constituted a, quote, different type of corruption, end quote. This was a corruption that distorts, but notice the distortion here is not a distortion of the politicians, it's a distortion of the people. The claim was this aggregate spending was changing the people's views in a way that distorted relative to what people would have thought had they not had the influence of that speech. So it was a corruption of us, the people, because of this inequality in spending. And so the remedy, according to Michigan, was to find a way to equalize that spending so that we, the people, would not be so distorted. Now, just about 4 years ago, the Supreme Court in Citizens United reversed their position. They said that was not corruption. We, the people, are not corrupted. That this influence, this distortion of the people can't be seen, or at least the court would not see it, or at least we could say the state can't remedy it. We, the people, in the sense, are on our own. We have to take care of ourselves. The government can't be a guardian of equality. Now, this view of the Supreme Court in Citizens United, though I think there's lots in that decision to criticize, I actually agree with. I actually do agree that inequality in speech on its own is not corruption. I don't believe distortion of speech on its own is a form of corruption. It would be if we were in the tradition of Demosthenes. Remember, Demosthenes was the Greek speaker who spoke so well that they forced him to put pebbles in his mouth as he spoke so as to equalize his effect on the audience. But I think in this sense, at least, we can say the United States is not Greece, at least not yet. So the point is, two kinds of corruption. The court has said effects on members can constitute corruption, and effects on the people do not constitute corruption. So then the question is quid pro quo corruption it? Is that the only kind of corruption that this court will see? Okay, there's a school of constitutional interpretation called Originalism. It's not very popular in the academy, but it's significantly popular in this academy, in the Supreme Court, where at least 5 justices have signaled at different times their commitment to this school of constitutional interpretation. An originalist interprets by understanding how the framers would have understood whatever question the court is considering. And that's not the end of the inquiry necessarily, but it's at least the beginning. The first step an originalist must take is ask, how would the framers have understood this particular question? For the question that we're talking about, is quid pro quo the only kind of corruption that the framers would have understood? What I wanted to do is to see how the framers would have understood this concept of corruption. What was their conception of corruption? Did they mean it to mean quid pro quo corruption only? Did they mean it to apply to individuals or to institutions? And if it applied to institutions, what would it mean for the institution to be corrupt? Now, to answer this question, I asked some researchers to look at this online source, ConSource, and find every instance of the word corruption in the framing period where the framers were talking about corruption in the context of ratification of the Constitution or other proceedings around the enactment of the Constitution. And the researchers found 325 instances where the framers were talking about, quote, corruption. Or maybe better like this. Okay, now I took those 325 instances and I asked the researchers to code them according to what was meant by corruption in the particular context they had identified. And these two researchers went through those 325 instances, each of them doing the 325 to verify the actual coding. And the findings here were quite dramatic. So first, of course the framers understood the notion of quid pro quo corruption. Of the 325 instances we found, exactly 6 times the framers were speaking of quid pro quo corruption, meaning 1.8% of the times they were meaning quid pro quo corruption. And when they were talking about quid pro quo corruption, they were always speaking of individuals. They were talking about individuals engaging in quid pro quo corruption. They never predicated that idea of institutions. But in the balance of the research that we collected, talk of individuals or talk of corruptions as applied to individuals was relatively rare. Only 43% were cases where the framers were talking about individuals being corrupt. Much more common in this sample was the talk of institutions being corrupt. 57% of the cases that we identified were cases where institutions were being described as corrupt. So for example, Parliament was corrupt. And the most common version of this kind of institutional corruption is something the framers spoke of as, quote, improper dependence. And in 9% of the cases, meaning 5 times the number of times they spoke of quid pro quo corruption, this was their conception. The problem was improper dependence of an institution. That constituted corruption. Now, for an originalist, what this should mean is that if corruption means anything, it must include the conception of improper dependence, or more sharply, only a non-originalist could limit the conception of corruption to quid pro quo corruption alone. Okay, when I discovered this fact, I considered it interesting. I always find my research pretty interesting, but this one was particularly interesting. And I spoke to the people at the Constitutional Accountability Center, and we came up with the idea that we would try to put this research together in a way that could present it to the court, in this case of McCutcheon. So we submitted this brief, and the brief now famously is the first brief ever to include a tumbler as an appendix. So there's a tumbler that actually has all of the quotes that we were using, and you can sort them by the tagging so that you can see what the quotes are, and we've set up an opportunity for people to comment and to criticize the way we've coded, so that we have an ongoing project of people evaluating our characterization of this original finding. Now, I was excited when we filed the brief, and I was particularly happy when we filed the brief that we elicited an immediate response from this great lawyer, Bob Bauer, who wrote a blog post. And the blog post was describing our brief. Academics are used to writing things that nobody ever reads or talks about, but here, within 12 hours, we had a response directly to this brief. But in this response, Bauer wrote, "It might be said that Lessig's theory is mood music that reinforces judicial disposition to uphold limits." Mood music. But he wasn't convinced that there was a legal argument that went from the argument we'd made of the framers' understanding to the conclusion that the limits should be upheld. Now, I was surprised by that, because it seems to me pretty obvious how one leads to the other. But if it is right now just mood music, let me add to that mood by filling out a little bit more exactly what the steps are from this claim about the original understanding to the conclusion that the limits in McCutcheon should be upheld. So among the many words that describe our Constitution, but that don't find themselves in the Constitution, like federalism, which doesn't appear in the Constitution, or the word separation of powers, which doesn't appear in the Constitution, or the word democracy, that doesn't appear in the Constitution, our Constitution is actually described as forming what was called a republic. But by a republic, it's clear in the Federalist Papers and throughout that the framers were talking about a representative democracy. And by a representative democracy, it's clear, at least in Federalist 52, written by Madison, that what they meant would be a government that would have a branch that would be, quote, dependent upon the people alone. Now, the people. Of course, the people didn't include, in this sense, African Americans and women. Let's bracket and flag that fact. But one incredibly important fact is that, according to Madison at least, the people included not the rich more than the poor. Federalist 57, explicitly recognizing that the institution of influence that the system was to set up was to equalize the influence across rich and poor. So here's their model of government. They have the people exclusively dependent upon by the government. And how was that dependence to be manifested? As Madison wrote, frequent elections are unquestionably the only policy by which this dependence and sympathy can be effectually secured. Okay, that's their model. Here's the problem. Congress has evolved a different dependence. Not just a dependence upon the people, but also a dependence upon the funders of campaigns. This is a dependence too, because as members of Congress and candidates for Congress spend anywhere between 30 and 70% of their time raising money to get back into Congress, it has an effect on them. It has an effect that produces a dependence. We need to think about what that life does to them as they spend their time dialing for dollars, calling tiny slice of America to raise the funds they need to fund their campaigns. B.F. Skinner, a Harvard professor, gave us this image, the image of the Skinner box, where animals learn which buttons to peck in order to get the sustenance they need. This is the picture of a United States congressman of our current time, as they learn over time which buttons to push to get the sustenance they and their party need to support the addiction, the dependence which has developed within the system. It is a dependence. But it is a different and conflicting dependence from a dependence upon the people alone, so long as the funders are not the people. Now here's the flash. The funders are not the people. The funders of campaigns do not represent the people. The funders of campaigns represent the tiniest slice of the 1%, which are not in any sense representative of the people. In 2010, as the Center for Responsive Politics calculated, 0.26% of America gave $200 or more to any congressional candidate. 0.05% gave the maximum amount to any congressional candidate. 0.01%, the 1% of the 1%, gave $10,000 or more to any congressional candidate. My favorite number from the last election is 0.2000042%. For you math whizzes out there, you know that's 132 Americans. Gave 60% of the super PAC money that was spent in that election. So as a lawyer, I look at this range, And I say, at the most, 0.05%, 1/20th of 1% of America represents the relevant funders of congressional campaigns, the tiniest slice of the 1%. It's upon that tiniest slice that our Congress is dependent. Now, this dependence is a corruption. It's not brown paper bag corruption with cash secreted to members of Congress. It's not Rod Blagojevich sense of corruption. Nothing I'm talking about is criminal or proscribed by any ethical rule. Indeed, according to the Supreme Court, it is constitutionally protected. I'm not talking about bad people violating the rules. I'm talking about decent people, people who are trying to do the best they can given their views, who live within a system that forced them into this dependency, a dependency that is a corruption relative to the framers' baseline for how this republic was to be designed. Their baseline of a system, of a government, dependent upon the people alone, or not the rich more than the poor. Because this dependence is a dependence of the rich more than the poor. It is a dependence that distorts and destroys the intended dependence the framers gave us. That is a corruption. And we could call it a dependence corruption. A corruption of the dependence intended by the framers. So if that is corruption, if that is a kind of corruption, how is it relevant to the case that will be argued next on October 8th from the McCutcheon versus FEC case? One of the most interesting passages in the Montana case, which effectively tried to reverse Citizens United in or for Montana, was a passage where they reflected upon research which looked at the relationship between limits on campaign contributions and the number of people contributing to campaigns. And what they found was that contribution limits changed the business model of fundraising. So if you remove limits, the business model of fundraising shifts to raising money from the largest possible contributors. And if limits are in place, you have to raise money from a wider range of contributors. In their case, they were pointing to limits on corporate contributions, and they found that states with limits in corporate contributions had 48% of the money coming from individuals, but when the limits were removed, individual contributions fell to just 23%. But that points in that research by Professor Bender to the fundamental dynamic that we can't ignore. If you eliminate the cap on aggregate contributions, the number of funders in the system will fall even more than it has so far. And if the number of funders drop, then the dependence corruption within the system, as I've just described it, only goes up. So what that means is that the aggregate limit reduces the dependence corruption inside the system, or most importantly, for a court focused on the appropriate role of a court reviewing legislation, or so a reasonable Congress could believe. A reasonable Congress could believe that the aggregate limits here are a way to assure that a wider range of people are contributing to campaigns than would be contributing if there were no aggregate limits. That's the first conclusion. Here's the second. If the original meaning of corruption must be said to include dependence corruption, then an originalist should permit Congress to act to reduce it. A consistent originalist cannot consider corruption to include only quid pro quo. Now that might be a mood. It might be a mood that characterizes the nature of this argument, but it's a mood that points to a principle that I've seen justices on that court respect more than the politics of a particular case. And if that principle operates in the way that I believe it does, it would entail that there is not a 5-4 decision striking these limits, but a much stronger majority upholding the limits in the name of affirming the framers' conception of corruption. Thanks very much.
we have about 10 minutes for some questions from the audience. We have Emily has a microphone that she'll hand around. So if there's questions, just raise your hand and we'll
Thanks. Thanks for being here today. It's awesome to see you speak again, especially on the eve of this case that's going to come down and do even more damage than Citizens United did to our democracy. Recently, a former president said that democracy in America can no longer be said to exist, and The Economist reported that we were falling into a state of flawed democracy in this country. I was just wondering what you think about that and what we're going towards, what type of political model are we approaching, and what can we do actually to fix this problem if the Supreme Court is going to keep making it worse?
Well, so first, I'm not going to accept your assumption the Supreme Court is going to make it worse. I'm the ever optimistic academic about the court doing the right thing, and I think this court will do the right thing in this case. But even if the court does the right thing in this case, there's an extraordinary amount of work left to be done to make this democracy function again. Because all that this will do is allow the current system to survive. And the current system is one which builds into it the capacity for dysfunction to continue to control the way Congress works. If you have a tiny number of people funding campaigns, which is what we have, what that means is an even tinier fraction of those people have the capacity to block any reform from the left and reform from the right. So that the business model of fundraising inside this city increasingly is the business model of dysfunction. Dysfunction and polarization ironically make it easier to raise money, and when your objective is simply the objective of winning in the next election cycle without a focus on governing, what it produces is exactly the non-governance that we have inside of Washington right now. So this will be an important victory. It will set the groundwork, I think, to rethink some of the worst implications of Citizens United. But we should not fool ourselves into believing winning in the Supreme Court is enough to win back this democracy. The only way we win back this democracy is with legislation such as John Sarbanes' legislation that would fundamentally change the way we fund campaigns. And that's got to be the fight that ultimately we win. A question back there.
When the framers talked about improper dependence corruption, whom were they concerned that Congress would become dependent on? Was it wealthy individuals or was it the monarch?
Yeah, so in part they were concerned about monarchs. My favorite clause in the Constitution is the clause that forbids gifts from kings and foreign princes. Because, completely reasonable that a banana republic getting born, the people in that republic would be very focused on the rich people of the world, which would be the French kings or other people like that, and you don't want members of the government having that kind of dependence. So that's one kind of nobility. They didn't focus so much on domestic nobility, however. It was foreign nobility. That's because it was a relatively egalitarian society. There wasn't the radical inequality that we now have within the society. And so, at least among members of the political class. And so what that means is they weren't thinking about the way in which funding in the context of an election might corrupt the system. Indeed, the framers didn't think you would spend money on elections. The framers imagined you would just put your name out there and the community would know who was the best person, and it was somehow unethical even to campaign. Presidential candidates refused to campaign for being president. They thought it was beneath them. And so the assumption of that time, of course, proved to be wrong, but the concern that they were talking about, to avoid the rich having an influence that distorts the way the democracy functions, is a concern that we can continue to respect today. And I think we should by recognizing legitimate efforts to limit the inequality produced by the current system of funding campaigns.
Emily.
If the court rules as you think it will, and if Congress follows up with some sort of additional regulation or public funding, Is this ruling going to be enough to eventually lead to the overturning of Citizens United, and what is the pathway?
Yeah, so, Citizens United is a confused decision, and there are different parts that we should separate. In my own view, the question whether a nonprofit filmmaker should be allowed to spend its money to promote its film is an easy question. I think the First Amendment protects that. But it's a separate question whether large contributions to independent political action committees can or can't be regulated. That question was decided not by the Supreme Court, but by the DC Circuit in a case called Speech Now. The DC Circuit, after Citizens United, said if independent expenditures can't be regulated, then contributions to committees that make independent expenditures can't be regulated. That logic, in my view, doesn't follow. It might follow if the only conception of corruption you have is quid pro quo corruption, but that's why this case is so important. If in addition to quid pro quo corruption, there's a conception of dependence corruption, then what we're seeing with super PACs is precisely the development of another kind of dependence corruption. Indeed, some believe even more virulent than the dependence corruption of direct contributions. So that would mean that the court would have the predicate not to limit the ability of independent groups to spend money, but the predicate to limit contributions to independent groups. That's why the point made at the beginning, I think, is absolutely right. The court has recognized a fundamental difference between regulating expenditures and regulating contributions. So I think the right constitutional line, even in light of the Supreme Court, is political action committees can spend whatever they can raise, but it's perfectly legitimate for Congress to say contributions to political action committees will be limited, whether they're independent or non-independent political action committees. And that would go an enormous distance in removing super PACs as a concern in this space, and again, focus on what I think the ultimate objective has got to be, which is to produce something like citizen-funded elections, the way, again, the Sarbanes bill or even the Fair Elections Now Act would have done 2 years ago.
I just want to add one thing to what Professor Lessig said. I agree with everything that he said so far, and I also share, to an extent, the optimism about the power of the originalist argument his scholarship represents and puts before the court. I think we also have to recognize, though, that we may not win this case, that we may not convince the 5 conservatives that corruption should be defined this broadly. And more broadly, folks in this room and folks out on the internet that are watching this program that care about our democracy and care about fixing the existing very serious problems we have in our democracy have to be very carefully watching what the Supreme Court is doing, because it has, in cases like Citizens United, already made it more difficult to fix the problems in our democracy. And if McCutcheon goes the wrong way, it will continue a trend that is very powerfully against the thrust of fixing the flaws in our democracy that I think so many of us care about.
So in light of all of that, I'm wondering strategically how, given that the court is probably not likely to or interested in overturning Citizens United or seeing itself overturned by Congress, even though they may have said Congress can do that, how do we, or I suppose the litigants, strategically convince the court that going with this definition of corruption doesn't lead to an overturning or doesn't have to lead to an overturning of Citizens United? And I'm wondering if that has to do with the distinction between hard money and soft money, or if it's drawing the line somewhere else, or if ultimately it convinces the court that, okay, maybe this does mean the end of Citizens United, but there's another principle at stake.
Yeah, I have written, and I continue to believe, that adopting the principle of dependence corruption does not change the result in Citizens United. Because dependence corruption had nothing to do with the question whether the organization Citizens United could spend its own funds to promote its film. The issue of dependence corruption gets triggered when you start thinking about contributions to independent political action committees. And so I think the court is completely open to say, look, nobody has ever presented to us so far a conception of corruption which is focused on dependence corruption as opposed to the kind of equality corruption that was decided in Austin. Nobody's ever presented it to us, and it wouldn't have been relevant in Citizens United. If it had been presented, then we would say, well, so what? That might be a conception of corruption, but even under the conception of dependence corruption, Citizens United wins in that case. So I don't think there's any reversal necessary. All the court has to do is to recognize that if it will stand on its principles, which for this court has two, the First Amendment and respecting the framers' conception of the Constitution they were promulgating, if they stand on those two principles, there's a way to continue to say Citizens United was rightly decided, but the implications of Citizens United that Speech Now take and many other people continue to believe, the court said, are just not necessarily implications. So you can have limits on aggregate contributions, that's McCutcheon. You can limit contributions to independent political action committees, that's what Speech Now wrongly decided. And so you could narrow the harm that was done by the explosion of these super PACs without the court having, in this sense, to lose faith because I don't think the court so far has crossed the line of making the mistake which we're trying to make sure they don't make. So I'm a law professor and I cold call on people. Okay.
One more question, I think, and we're about out of our time, so this will be the last question.
Just the question would be that if Citizens United is correctly decided, that means that corporations could spend independently from their own treasuries and continue to do that. How is that not a separate source of dependence, that doesn't require a contribution in the first place?
Yeah, it might well be that even fixing the contributions to political action committees, there still is a concern about the way the system has produced the wrong kind of dependence. And the reality is we have to see how it develops. The fact is, since 1976, rich people have been free to spend their money independently of political campaigns as much as they want. But we didn't actually see it. In fact, the numbers, we just give you the change in outside spending. From a period of time from 76 on, there's basically nothing. And then after Citizens United and Speech Now creates the independent super PACs, that's where you see the explosion in outside spending. So what that means is formally they could have done it before, but they didn't. But this really handy device called the super PAC produced this, will destroy the handy device of the super PAC. And it's not clear to me where we go, whether we go back to something like that or maybe we produce what you're talking about. I'm not saying we won't need to address that problem someday, but here's the really important point. We cannot focus our reform effort on fixing Citizens United. Because even if we succeed, even if we reverse Citizens United, we still have not begun to address the basic problem of dependence corruption, which is produced not by independent expenditures. It's being produced by the wrong structure of funding campaigns. So we need to change that. And that's why the political movement inside this building to build support for citizen-funded elections is, in my view, ultimately the most important fight. There's an important fight. There are important fights in the court across the street, no doubt. But winning all those fights still will not get us close to a democracy we have a reason to trust again. And so focusing on that, I think, has got to be the work of the reform community.
All right, well, thank you, everyone, for coming here today. And with that, we'll adjourn.